May it please the court. I am Larry English, and I represent Sharon Lewis, and I will be addressing the following issues this afternoon. At the motion to dismiss stage, it was an abuse of discretion when the district court failed to address why appellees are not equitably stopped from raising a statute of limitations defense where LSU attorney Vicky Crochet misled appellants about Miles' misconduct. At the motion to dismiss stage, it was an abuse of discretion for the district court not to find that fraudulent concealment applied to appellants' RICO claims from 2013 to 2017. At the motion to dismiss stage, it was an abuse of discretion when the district court made impermissible credibility determinations on the issue of causation. If time permits, appellant will address Crochet's, Barton, and McKenzie's improper motion for summary judgment, raising the affirmative defense of res judicata for the first time on appeal.
Make sure I understand the claim. The injury that your client is seeking recovery for is for her failure after the difficulties arose 10 years ago or so, to be promoted, to receive a bonus, to otherwise be advanced. That's the underlying injury. Is that correct?
The underlying injury, yes, Your Honor.
Okay, now, I know you want to add to it.
Sure.
Before you add to
okay.
it, let me ask you one more thing. You are also, the issue before us is really the civil RICO aspect of this, it seems to me. As you see it, does the conspiracy that you're alleging hide the injury, add to the injury? What is the relevance of the RICO aspect of your claim to that original injury?
Your Honor, that issue is not before the court, but appellant will answer the question. Certainly the conspiracy...
Why is that not before us?
Your Honor, the district court dismissed the appellant claim for 3 reasons. Those 3 reasons were, first, that appellant did not, her claims from 2013 to 2017 were not timely. Her claims from 2017 moving forward to 2021, appellant did not show that her injuries were directly caused by the RICO conduct. And the court, the third one was, Your Honor, was that the RICO court, the district court ruled that the injuries from 2013 to 2017 was not directly and proximately caused by the appellee's RICO conduct. The conspiracy was based on a concealment. The appellees came together in 2013. They agreed to conceal the Miles investigation. They agreed to conceal the student complaint memo. They agreed to conceal the directive letter. Appellant was the only employee in the LSU athletic department that repeatedly reported Title IX violations. In order for the appellees to be able to conceal the Miles investigation, conceal the student complaint memo and directive letter in their offices, they retaliated against appellant and they injured her. Additionally, appellant has argued that as a result of their RICO activity, they placed appellant back under Les Miles' direct supervision, where Les Miles, Joe Oliva, an additional appellee, and other individuals injured her business by failing to promote her, by failing to give her bonuses, and otherwise injuring her employment. The federal courts have held that an employee has a property right interest in their employment. So the conspiracy, the act of concealing the Miles investigation and those documents, in order for the appellees to have completed this illegal scheme, they had to ensure that the appellant would not continue to move forward with complaints in the Title IX investigations. And in the appellant's complaint, she repeatedly stated she was told, you need to find another job. She was repeatedly passed over for promotions. She was repeatedly isolated in the athletic department. The Hush-Blackwell report that LSU contracted with did a complete analysis on these issues, and they found that the appellant was the only individual in the LSU athletic department that reported Title IX complaints. She was the only individual in the LSU athletic department that was ever subjected to a PS-73 action. Appellant alleges that this PS-73 action in 2017 and 2018 was the direct result of the criminal enterprise continuing to retaliate against appellant and to force her out of her job in order to keep the conspiracy concealed. So, Your Honor, the conspiracy goes directly to the fraudulent conduct. In conspiring to keep their criminal conduct secret, they did several things. They concealed the student complaint memo in the Taylor Porter lawyer's offices off-site away from the university. They concealed a directive letter that was sent to Les Miles off-site in the Taylor Porter law offices and in Ginsberg's law offices. They agreed when they concealed the directive letter that if anybody would seek these documents, LSU was to notify Les Miles, and they were to go to court and to fight the release of the document. So the conspiracy of hiding and corrupting a Title IX proceeding goes specifically to the fraudulent concealment of which appellant is alleging here today.
Well, that was an elaborate answer, but thank you.
Thank you, Your Honor. Appellant alleges that she was misled by attorney Vicky Crochet in 2013 that Les Miles' sexual harassment of student 1 and student 2 was not a violation of the law. Crochet's intent was to induce appellant from pursuing her legal claims against Miles and LSU.
Did Crochet do anything to discourage your client from seeking her own counsel?
No, Crochet did not do anything to seek the client from my client from seeking her own counsel, Your Honor. As to whether or not appellant took reasonable steps in order to investigate her claims is a fact-based analysis that is inappropriate for the district court to have made at the motion to dismiss stage. The Hush-Blackwell report stated that appellant was the only employee in LSU athletics that reported Title IX violations. The record shows that Crochet was aware of that in 2012, appellant had reported that Miles threatened her employment multiple times. Appellant reported that Miles promised her job to student 1 in order to groom her for sex. It was appellant who reported that Miles had sexually harassed student 1 and student 2. In the record are emails, Peter Ginsberg's state court testimony, the Hush-Blackwell report, the district court ruling showing that while Crochet and Barton were tasked with undertaking an impartial Title IX investigation, they were actively conspiring with Miles' attorney, Peter Ginsberg, to conceal material documents, alter material documents, and to bribe student 2 to drop her complaint against Miles and LSU.
Also, one of the questions I have about this case is, when is there concealment for fraudulent concealment, and when is there just a non-public record, such as the report of an investigation? Isn't there a line to be drawn?
Your Honor,
Anything
again,
that wasn't made public as part of an investigation, concealment for purposes of fraudulent concealment?
Your Honor, the student complaint documents are public documents. The directive letter are public documents. The district court has ruled that the appellees likely acted in furtherance of a crime when they concealed the student complaint memo and the directive letter in their offices. So the district court has adjudicated that issue and found.
In part, what about the document reporting on the investigation that was done that was at a report was at a law firm? You've argued, seems to me, that's the most significant document in play, and I'm not sold one way or the other whether it was concealed or just a confidential document.
Your Honor, the PS 73 Title IX policy required that once it came to LSU's attention that student 1 and student 2 had accused Les Miles of sexually harassing them, a Title IX investigation then took place. If you look at the student complaint memo, the Taylor Porter lawyers specifically state in that memo that we are in the place of LSU's Human Resources Department, because the PS 73 policy, which is a Title IX document, required them to do that. So a PS 73 document, these were documents inside of a Title IX investigation. They were required, Your Honor, to not conceal these documents in their offices, but they were required to report this to the Office of Civil Rights. They defrauded the Office of Civil Rights by concealing these documents, which were a part of a Title IX investigation. The other issue is, Your Honor, again, the district court has found that they likely acted in furtherance of a conspiracy when they violated these documents, when they concealed these documents, because they were public documents at the time. Moreover, this was not garden variety attorney misconduct. The record shows that Crochet actively lied to appellant. Crochet likely acted in furtherance of a crime to conceal material documents in a Title IX investigation, and Crochet acted to defraud the Department of Education by concealing the Miles investigation from the Office of Civil Rights. Assuming that the allegations in appellant's complaint are true, it was reasonable for appellant to believe that if Miles' misconduct toward the student was not illegal, his misconduct toward appellant was not illegal also. The record shows that Crochet and Barton advised LSU on all athletic Title IX issues. The record shows that Barton and Crochet conducted sexual harassment training in LSU. The record shows that Crochet and Barton's law partner, Shelby McKenzie, was acting as general counsel for LSU. It was reasonable to believe that appellant would believe Crochet's misleading legal opinion. In any case, this court has ruled these are disputed facts that are for a jury to decide, not a district court at the 12B6 stage. As to whether appellant undertook a reasonable investigation is a fact-based analysis. Appellant undertook a reasonable investigation when she asked Crochet, what are the next steps in the Miles investigation? It is important to note that in the record, it shows that during this same period, appellant had a nervous breakdown. The court is not prevented from considering appellant's mental health as a factor in determining whether a similarly situated individual would have relied on Crochet's misleading opinion. Moreover, the district court failed to address in any of its rulings dismissing appellant's RICO claim why a similarly situated individual would not have been misled by Crochet's fraudulent legal opinion. That was an abuse of discretion. Furthermore, appellant alleged in her complaint multiple affirmative acts by appellees to conceal their fraudulent criminal conduct. For instance, appellant...
Counsel, if I could just ask you something. We're still talking about prescription, right?
Yes, Your Honor.
Do you agree that the appellant's injuries, I guess, are we in agreement about when the injuries accrued or when the claim accrued? Because we're talking about equitable tolling, right? So are we agreeing when they accrued?
Your Honor, claims accrued in 2013.
Okay.
Claims accrued in 2018. claims accrued in 2020.
And the ones that accrued before 2017, they accrue upon discovery of the injury. Is that correct?
Yes, Your Honor. This circuit has an injury discovery rule. But once appellant alleged fraudulent concealment, once appellant alleged that she was misled, that became a fact-based
I get that.
analysis.
Yeah, no, and I understand your argument. I just wanted to understand if we were in agreement about accrual. So when we're thinking through the equitable tolling, do we need to be thinking about all of this fraudulent concealment and whether it prevented her from discovering her injuries or something else?
Your Honor, it prevented her from knowing when she had a viable RICO claim, and as to whether or not her injuries were the result of a conspiracy.
What is your best case for the idea that equitable tolling is not about fraud that prevents a plaintiff from discovering his or her injuries, but instead other elements of the claim?
Your Honor, Petrovas versus Samsung, Inc., Waste Management of Louisiana versus River Birch has specifically stated the questions that you are asking are an issue for a jury to decide. Okay. These are disputed facts, and they are not. It is impermissible for the district court to decide those issues. Furthermore, appellant alleged in her complaint multiple affirmative acts that appellees took to conceal their fraudulent conduct. For instance, appellant alleged that Jacob stated in a Sports Illustrated article that the Taylor Porter lawyers directed him not to disclose the Miles investigation to anyone. Jacob stated in the same article that is in the record, he told no one, not even his wife. Appellant's allegations of fraudulent concealment are supported by emails, Ginsberg testimony, and findings of fact in the district court crime fraud ruling. And to come back and to address your issue, Your Honor, the law is clear that once it is established that a defendant has engaged in fraudulent concealment or has actively misled an individual as to their legal rights, they are equitably stopped from exerting a statute of limitations defense.
What would, go ahead.
Did your client take any additional steps to uncover any fraud besides asking Crochet what's next?
Your Honor, the law requires the appellant to undertake a reasonable investigation. She is not required to take extraordinary investigation to discover her injuries. Again, this is a fact-based analysis where the district court failed to follow the law. In all of the rulings that the district court made, the district court did not undertake an analysis to determine whether or not a similarly situated individual would have relied on Crochet's misleading statements.
Well, is your answer then no?
Your Honor, my answer is, Your Honor, straight to the answer is, she relied on Crochet's misleading statements to her, and she did so because of Crochet's long-term history of working with her. In Reeves versus Equal Employment of Atlanta, that is a similar case. In that case, the Fifth Circuit held that where an appellant was misled as to by her of her legal rights, that the defendants were equally stopped from asserting those claims. They specifically looked at the fact that the plaintiff in that case had a relationship with the EEOC. They knew who they were, and that based off of that relationship, she relied upon their advice. In this case, Sharon Lewis was well aware of who Vicky Crochet was and Bob Barton and Taylor Porter was. They had conducted sexual harassment investigations. They had conducted sexual harassment trainings. So, Your Honor, it was reasonable for her to rely upon that misleading opinion. But again, Your Honor, the Fifth Circuit has held that these disputed facts are for a jury to decide, not for this court to decide, nor for the district court to have decided at the trial court level.
English, your focus from my colleague's question makes me wonder, are you saying, were we to decide, I'm in no way suggesting we would, that the district judge was right to say it was unreasonable to rely on what Crochet said? Is that the case?
Your Honor.
I mean, you got all your issues about fact.
She made no ruling.
Mr. English, you have all your issues about that. Is it really a fact question for the jury, whatever. But put those aside. If it was not reasonable for her to rely on Crochet, what's left of the case?
Your Honor, if a court would find, answering your question, if it was unreasonable for appellant to have relied on Crochet's, then the statute of limitation as to for her claims from 2013 to 2017 would be lost. But she has additional claims and injuries starting in 2018 and starting in 2020 and 21. The issue, though, Your Honor, with all due respect, is that the court didn't make that determination as to whether or not it was reliable.
The only reason for asking that question, which I know you would totally reject the premise of it, is to see the correlation between that statement from Crochet and your emphasis on the RICO conspiracy, which seems to me is your principal argument as to why whatever she said, the conspiracy was still hidden and was continuing to hide the legitimacy of her claim.
Correct, Your Honor.
All right.
Assuming that appellant allegations in her complaint are true, and given her every inference, the district court ruling that appellees were not equitably estopped from asserting a statute of limitation defense from 2013 to 2017 at the motion to dismiss stage was an abuse of discretion. The district court, as to appellant's 2013 claims, from a 2013 to 2017 claims to a 2018 claims and to her claims in 2021, the district court made impermissible credibility determinations in dismissing appellant RICO claims based on causation. It is dispositive that the district court did not find that appellant did not state a claim. Instead, without any discovery having taken place, it reasoned there were too many events that had to happen between appellee's misconduct and appellant injuries. The district court then, without any discovery having taken place, speculated a list of events that had to occur in 2013, 2017, and 2021 before appellant was injured. The district court could not have reached these conclusions without making an impermissible credibility determination that appellee's alternative arguments were more credible than the appellant's allegations of fact. This was an abuse of discretion. As an example, appellant alleges in 2021, Osbury told her, "You will never be promoted because you used the word Title IX too much. You even filed a complaint against me." Appellant alleged that this was a violation of 18 U.S.C. 1512 A2A. The district court found that Osbury's conduct was not the direct and proximate cause of appellant injuries. The district court simply could not have reached that conclusion without making an impermissible credibility determination that it believed Osbury and not appellant. This was an abuse of discretion. Again, Your Honor, this court in Waste Management of Louisiana versus River Birch specifically addressed this issue, and the court said that at best, the appellees had raised disputed issues that were best resolved for a jury. Also, Your Honor, Petrovas versus Samsung, this court made the same determination on the same set of facts that when these issues are presented to a district court, that they are best resolved and they are the purview of a jury to make. The Taylor Porter defendants have pending before this court an improper motion for summary judgment of raising the affirmative defense of res judicata. The U.S. Fifth Circuit.
You want to hold that?
Okay.
raise it where you can.
Okay.
Thank you, Counsel.
Thank you, Your Honor.
Where appellees, you have worked through carefully, I'm sure, your division of time. Ain't much, is it?
I understand, Your Honor. Thank you, Your Honor. Jimmy Faircloth, I represent defendants Danos, Yarboroughs, and Jacobs. As the court is aware, on the acknowledgement argument form, we've divided it up to try to make sense out of the arguments. There's a lot of lawyers here, a lot of parties. Everyone has something important to say. I will do the best I can with the 6 minutes that that has been devoted to me. So if I seem to be hurrying, I am. And if I stop short, please understand I'm just deferring to my colleagues have a chance to make their say. Your Honor, the most difficult part of this case is that it's a nest, it's a thicket of sound bites from different areas of the law. The actual ruling here is very clear in terms of accrual and prescription. The issue I'm here to talk about is the injury accrual rule in the Fifth Circuit. When did the claim accrue? When she had knowledge of the injury. And I listened to the arguments, I've read their briefs many times, and they didn't argue even separate accrual rule. This circuit has a separate accrual rule, where if there's subsequent events that happen that causes subsequent injury, you can have the accrual of a new claim, essentially. Here, this is a pure accrual issue, as Judge Duncan pointed out. And I would point to the court, the reason it's kind of tangled is because this case has a lot of allegations and a lot of people sued and a lot of claims, and the district court here did a remarkable job of using her authority to weed this case down to what it really is. And what it really is a Title IX retaliation claim. And that's back in the district court right now. And plaintiff will have their day. This is not a RICO claim. This is not a broad conspiracy claim. The claims here, the prescription statute of limitation claims, are the easiest to decide. And they begin and end on Mr. English's acknowledgement a moment ago when asked very directly, are you talking about the discovery or concealment of injury or rights? And he says rights.
Counsel, let me ask you, one of the things I've been working with on your argument of your friend on the other side, it seems to me the RICO claim itself is an injury. If there's a conspiracy against someone that fits within RICO, that is a separate analysis. But as I understand the RICO claim here, it's the hiding of the fact that she actually, that there actually was a Title IX violation, that she shouldn't have relied on crochet. Tell me how you see the RICO is being argued as fitting with the injury and why that doesn't work.
It doesn't work here, Your Honor, because, first of all—
How do you see it fitting? What is the argument here as you understand it from Mr.
Well, that's the disconnect. They're arguing equitable tolling based on fraudulent concealment. So far—
Conspiracy.
Correct. Consider the conspiracy to suppress information, if you will. Well, for accrual purposes, if he was talking about information about her injury, then we're on the right footing to have that analysis. But he steps away from that analysis and gets into this idea of there's some conspiracy to suppress the student report, conspiracy to suppress the Les Miles report, none of which is remotely relevant to the issue of accrual. It's just not. It's not. And
I heard just now in the argument talked about the continuing Title IX violations that were going on after 2013-14. Is that in this lawsuit?
yes.
Or violations that happened 18, 19, 20?
Yes, sir.
Promotions and whatever.
Yes, sir. That's what's back at the district court.
That's still back in the district court. But he's saying that this conspiracy was hiding various aspects of knowledge about that suppression of her rights under Title IX, or that violation of her rights. I mean, I must say, in fairness to the plaintiff, there may be an argument here, but I wanted you to help me to see what you think that argument is, even if you would give it the back of your hand.
Well, I think it's hard to follow because it doesn't square with the law. There is no cause of action, personal cause of action, by her for conspiracy to hide some public document that she claims creates a RICO entitlement recovery. And Mr. Cullens will address RICO in a moment, but that's the problem. They're talking about apples and watermelons. We're talking about concealment, fraudulent concealment for purposes of accrual of prescription, a claim. He's talking about concealment with regard to rights under the Louisiana Public Records Law. Now, that may be a predicate act. That may be a predicate act. But that's a different issue. You don't get to the predicate act when you're talking about accrual of a claim. And I'll take the court real quickly through. There used to be 3 theories for statute of limitations for RICO. Injury discovery rule, which the Fifth Circuit has always recognized. The Fifth Circuit has gotten this right. And there were other circuits that recognized other variations. One was called the predicate act rule. And the claim was it doesn't accrue until the last predicate act occurs. And the other was it doesn't accrue until the injury plus discovery of the pattern of RICO activity. The Supreme Court has rejected the former, the last 2. And the second rejection of the injury and the plus pattern discovery was the Rotella case, which was a Fifth Circuit case, which affirmed the Fifth Circuit's decision. It is clearly an injury discovery rule. And in ruling, and Judge Morgan does a really good job in the opinion of going through what the case has said and why the focus here is, did the defendants do something to conceal her knowledge of her injury? They have a section in their reply brief that actually says this: the exhibits, quote, show appellees taking affirmative acts to fraudulently conceal racketeering activity. That simply is not the standard. You can't point to the concealment of the alleged misconduct as a barrier or as some reason to forgive the running of the clock on the accrual of the claim. And in Rotella, the United States Supreme Court...
Running of the clock.
My clock is run. Thank you, Judge.
I wasn't sure you'd pick up on what I...
No, I did. That's very good.
Good afternoon, Your Honors. May it please the Court, Brooke Barnett-Bernal, and in addition to Mike Patterson and Seth Lawrence, we are here on behalf of Joseph Oliva. I'd like to adopt the arguments related to statute of limitations by Mr. Jimmy Faircloth. As he mentioned, I'll focus on the proximate causation and injury for civil RICO, both of which are necessary for Ms. Lewis to establish standing, both of which she has not done. So, under the proximate cause analysis, you have to establish that injury recoverable under RICO that was proximately caused by the alleged predicate acts. That is what is required to satisfy the proximate cause. It's lead directly. It's a direct connection. So she must establish the alleged predicate acts led directly to her injuries. Based on her own allegations, taken as true, which was required under the Rule 12b-6 motion dismiss standard, show that her injuries were proximately and directly caused by employment-related decisions. Decisions to deny her promotions, pass her over for bonuses, for pay raises, other professional development opportunities because she allegedly reported Title IX violations. They were not caused as a direct result of the alleged predicate acts. And that is clear based on her own allegations. Lewis also alleges employment-related injuries. These employment-related injuries, those are not recoverable under RICO. Being denied bonuses, passed over for promotions that Lewis expected or wished to receive is not a concrete or conclusive loss. Those are injury to expectancy interests, which the law of this court has found are not sufficient to allow standing under RICO. She alleges loss of professional development opportunity. Those are just not concrete, conclusive financial losses. Loss of future wages, earnings, those are speculative. Those are not concrete financial losses, not recoverable under RICO. This court has long held that whistleblowers do not have standing to sue under RICO for the loss of employment benefits. So RICO is just not designed to insure against every injury or every loss, every wrong that may be able to be traced back by the plaintiff to an alleged predicate act. The fact, again, as Mr. Jimmy Faircloth said, the fact that she doesn't have standing under RICO doesn't mean that there's not a remedy under the law. She may have a Title IX, Title VII claims. Those claims are currently pending before the district court. But she doesn't have standing to bring a RICO claim because she has not established that the alleged injuries were the direct result of the alleged RICO acts. So for these reasons, we ask that you affirm the district court's June 2022 opinion dismissing the claims against Mr.
I want to be sure I'm asking the question at the right
Absolutely, that's
place.
what.
So if I'm not, just
Absolutely.
tell me that I'm off. I thought that Mr. English made the point as to the causation, that all of the different steps that the district court talked about, and between the RICO violation and the injury, were effectively, I think he said, making credibility determinations. I think that's his argument. If that's correct, what is your response to that? Because I have read those parts of the district court opinion, and yes, she lays out all the different steps that you'd have to do to get from RICO to the injury.
That's right. They're all based on the allegations that Lewis herself has in the complaint. They're not credibility determinations. They're based on the allegations that were made in the complaint. Each step is what she alleges in the complaint was what led to her injuries, the employment-related injuries. And in oral argument before the district court, she also references the transcript where she asked those specific questions: is how does the injury how was the injury caused? The injury was caused by the decisions by the employer to deny her pay raises and promotions. That the denial of a pay raise, of a promotion, is not a RICO predicate act.
Okay, thank you.
Any other questions, Your Honor? Okay, thank you very much.
Your Honors, may it please the Court, my name is Jay Cullens, and I represent the Taylor Porter defendants Vicki Crochet, Robert Barton, and Shelby McKenzie. I am here to address why it's not addressed by Judge Morgan in her 40-something page ruling, but why appellant fails to state a RICO claim by failing to allege sufficient facts to establish any of the elements of a RICO claim. Before I get into my argument, just to pick up on Ms. Bernal's comment, in the context of legal standing, loosely referred to it, proximate causation has been recognized in the cases cited by Judge Morgan in her ruling as a legal determination. You accept the pled allegations as pled by appellant, and you make the determinations as a sitting district judge as a matter, a legal issue, on whether the proximate causation, whether the alleged racketeering activity resulted in a injury that's recognized by RICO precedent. It clearly is not in this case.
We even be addressing res judicata. It wasn't raised until very late.
Yes, Your Honor. The rulings of the district court in the 19th and Judge Morgan's, not the judgment was rendered in September of 22, but her reasons, her order and reasons came out 4 days before the judgment in state court was signed on June 20th. Appellant immediately filed an appeal in state court, then for, in my opinion, inexplicable reasons, voluntarily decided not to pursue that appeal and dismissed it as essentially abandoned at a separate hearing in December of 2022. By that point, the appellate brief had already been filed. Our brief was due the week after New Year's Eve. We waited until all appeal delays on both the June 20th, 22 final ruling and the decision to not appeal it were final, non-appealable. This is a dead issue. Your Honor, obviously, if you take up, it's within Your Honor's discretion. This is, I respectfully suggest, atypical. Typically, res judicata is an affirmative defense that should be pled in an answer in pleadings in the district court. It should be first addressed by the district court. But in exceptional circumstances, in the Stanton, jumping to the tail end of my outlines, Your Honor, but in the cases we've cited, Stanton, Husted, Lusher, J.O. Anderson, in all of those cases, there were exigent circumstances that, in effect, excused an appellant's not raising the issue first in the district court. Here it would have been very strange. We had just gotten a ruling dismissing plaintiff's claims on standing and prescription to some weeks later say, well, Judge, belts and suspenders, that's not good enough. It's res judicata. We did.
Counsel, it is something we will discuss, no doubt. It's before us once you move on to your other issue.
Yes, Your Honor. Back to the failure to state any of the elements of a RICO claim. Judge Morgan decided this issue, as Your Honors well know, on prescription and standing. So even if assuming there were some reversible error on those two issues, which there are not, appellant does not come close to establishing a RICO claim under Section 1962C, primarily that the defendants conducted an enterprise through a pattern of racketeering activity. Appellant must meet each and every one of those elements. The failure of any of articulating or pleading adequately any one of those elements is fatal to a RICO claim. Appellant did not plead that the Taylor defendants conducted an enterprise. Appellants repeatedly amended. We counted them up 11 times. If you count their RICO statements along with their amended complaints, they tried 11 times to articulate the elements of a RICO claim. In no instance when you read those 11 pleadings, all of the conduct of the Taylor Porter defendants is restricted to a 7-month period from approximately March of 2013 to September 2013, when they did what attorneys do. They represented their client, LSU, they provided advice, and their client made decisions. That's it. That's the isolated conduct that appellants try to bootstrap and turn into some type of RICO claim. With that individual attorneys performing as attorneys, it is simply appellants trying to take a square peg and fit it into a round RICO hole.
Help me make sure the source of that effort. I'm looking at what I think is the final, the live complaint, Second Amendment complaint, fourth version. As I understand the complaint, it asserts 4 different bases for a RICO claim. 2 of them have to do with the Miles report being not being made public, and then there are 2 other versions. To the extent we want an understanding of the RICO claim here, is that where we find it, in this Second Amendment complaint, in those 4 assertions?
Yes, Your Honor. The initial ruling leading to why we're here today occurred in early December 2021, and Judge Morgan gave appellants an additional attempt to amend their complaint once again to try to assert an injury that occurred after April 8th, 20... The second amended complaint is the operative complaint for this appeal, which led to the June and September rulings. Yes, and that dovetails with my argument before Your Honors. Where's the person separate and apart from the enterprise? When you read the 11 attempts at articulating or pleading adequately a RICO claim, there is no distinction. The person RICO, if you read it, it's the same as the alleged enterprise. I'm sure Your Honors have probably heard RICO claims on appeal, and I'm sure I'm stepping into the trap of going to the most widely known example, the Godfather scenario, where the Corleones run an olive company. That's the front, that's the person from a RICO standpoint. And then they have a structured enterprise where they do gambling, illegal alcohol, other illicit criminal activities that fit nicely into the RICO Predicate Act standard. That's a person, the olive oil company, that's separate and apart from the enterprise. There is no allegations other than a jumbled up mix of conclusory statements that articulates a RICO person separate and apart from the RICO enterprise. Very quickly, no continuity, at least as to the Taylor Porter defendants, is 7 months of conduct. Although the Fifth Circuit has not articulated a categorical standard for RICO purposes, it's been suggested that you have to have at least more than a year of multiple predicate acts that constitute a pattern. Here, with respect to the Taylor Porter defendants, we have activity over a 7-month period, one thing that's not even a predicate act. The appellants fail to allege any of the elements of the 5 predicate acts as listed in the RICO statute: mail fraud, wire fraud, tampering with a witness, retaliating against a witness, interstate travel. Appellant does not even make an attempt to articulate the elements, much less show, pursuant to Rule 9b, how the facts of this case, she articulates any of these predicate acts. That in and of itself makes it her RICO claim fail. There are no, although we all listen to appellant's counsel argue about a conspiracy, but when you read those 11 amended complaints, there's no articulation of who, when, where, how there was an agreement between these very disparate leaders of LSU, presidents, Athletic directors, outside attorneys, it's simply, again, there's not even comes close, although Judge Morgan doesn't address it. As you know, the appellate record is before you, and even if the basis is not articulated in the ruling, if somehow, which we don't believe it should be, the standing or the prescription is overturned, there's ample record evidence or a basis for the dismissal. This is simply not an organized crime RICO case. I have run out of time, Your Honors, but I'm happy to entertain any questions that you may have.
You've gotten our questions already. Thank you.
Thank you.
We have a few more, a little more than usual.
May it please the court, my name is Peter Ginsberg. I'm here on behalf of Leslie Edwin Miles. On the face of the complaint, Ms. Lewis alleges that there were 2 student complaints against Mr. Miles in 2012 and 2013. Ms. Lewis alleges that she reported those 2 complaints in 2012 and 2013. Ms. Lewis alleges that the retaliatory acts that she purports were undertaken by Mr. Miles occurred in 2012 and 2013. There are no allegations whatsoever, no matter how fictionalized, after 2013, and on September 25th, 2016, Mr. Miles was terminated from LSU. Judge Morgan ruled correctly that there is no circumstance, no reading of the complaint, by which any of the claims made against Mr. Miles, whether credible or not, I think counsel forgets these were 12b-6, not Rule 56 rulings. Judge Morgan ruled that by any reading, the claims against Mr. Miles were stale. And when Ms. Lewis tried to make it an even dozen and tried to amend the complaint again, as Judge Morgan found, on the face of the complaint, there is no reading, no interpretation, no re-allegation that could make those claims against Mr. Miles anything but stale. Judge Morgan didn't address any of the other multitude of reasons why the complaint fails. But on that ground, I respectfully ask the court to affirm Judge Morgan's decision with regard to Mr. Miles. Thank you.
Still a couple more, Mr. English.
Good morning, Your Honors. May it please the court. My name is Camille, Bryant, and I'm appearing on behalf of appellee Scott Woodward. In the interest of judicial efficiency, I would like to adopt all of the arguments that have been made thus far by the other appellees in this matter. In addition to the arguments that have been made, just to address the allegations regarding Scott Woodward specifically, can really be boiled down to one point. Did Woodward conspire to commit a crime by merely accepting a position as the athletics director of Louisiana State University? That is the only issue that is at bar with respect to my client. Woodward joined the LSU staff in 2019. As you've heard, all of these allegations pertain to conduct that allegedly occurred in 2013 with regards to the alleged concealment of the Miles report and the Miles directive and the student memo, none of which Woodward is alleged to have been a participant in, none of which Woodward had any knowledge of, nor is there any allegation that he had any knowledge of these facts. Furthermore, with regards to the alleged conspiracy, because that's the only claim that's been alleged against my client, and that in the Second Amendment complaint, the appellant alleges that Woodward engaged in Scheme 5, which she categorizes as the ongoing scheme to control LSU's football program, in violation of 18 U.S.C. Section 1962D. By the very definition of his title, Woodward's job as the athletic director is to manage, control, and direct the athletics of LSU. And so that in and of itself is not a conspiracy. And plaintiff has merely alleged the blanket and naked allegations which are not sufficient to defeat a motion to dismiss. Further, as Mr. English had stated momentarily ago, he referred the court to the Hush-Blackwell report, which is incorporated by reference into the complaint. And he stated, quote, "They did a complete analysis of these issues. In reviewing the Hush-Blackwell report, it specifically talks about the training that was instituted by Scott Woodward. It specifically talks about the Title IX complaints that were then sort of restructured under his administration. And so by appellant's own arguments, she shows that Woodward didn't do anything in furtherance of an alleged conspiracy, which is the standard that she would be required to prove." Moving on to the issue of judicial notice, Mr. English and appellant asked the court to take judicial notice of 2 district court decisions as well as documents that have been produced in discovery. Notably, none of the appellees were parties to any of those decisions, as those decisions were rendered by the district court pending this appeal. And so while we certainly acknowledge that this court may take judicial notice of other court rulings and court proceedings, that is simply not what Mr. English is asking the court to do. Rather, appellant is asking the court to do. Appellant is asking the court to make inferences regarding impeachment testimony and the intent and the motive behind certain actions that none of the appellees were in fact even parties to. The ruling that the district court rendered was respect to Louisiana Revised Statute 14-132, which is injuring a public record under state law. That is not a RICO predicate act, even if it was found to be a viable violation of the law, which we certainly don't believe that it is. And in order for the court to take judicial notice, it must be of a fact which is not reasonably in dispute. Whether or not there was a violation of injury of a public record is certainly in dispute, and it's not a fact. It's a issue of fact and law, so it is not appropriate for judicial review. Furthermore, that decision was only with respect to LSU. It was not subject to any of the other parties in this case. And if the court were to accept appellant's logic and that it is a fact, then the court would also be required to take notice of the fact that the court also ruled that there was no corrupt influencing in that decision, ruled that there was no bribery, there was no conspiracy, there was no obstructing of an official investigation. So all of those things would also be having to take into consideration, and under that logic, it would further support the arguments that were made by Mr. Cullens and that there is, in fact, no RICO violation. Thank you, Your Honors.
Good afternoon. May it please the court. My name is Mary Ann White, and I represent Miriam Seeger in this matter. And also, for purposes of this argument, I'm also going to be speaking on behalf of Mr. Osbury, Verge Osbury, who's also an appellee, just because of our limited time. I'd like to first adopt the arguments of the appellees in this matter. They all equally apply to Ms. Seeger and to Mr. Osbury. And I'd also, I just want to focus the court's attention on one issue in this case, and this revolves around a 2018 PM 73 investigation of Sharon Lewis, the appellant. And in that instance, Ms. Lewis has accused Mr. Osbury and Ms. Seeger of making false statements in their interviews as part of that investigation. And she claims that those false statements, those alleged false statements, caused her the employment injuries that ensued or allegedly ensued after. And so I want to focus on that because one of the arguments, and it was pointed out by Your Honor, is that the court had to make a credibility determination in order to find that proximate cause did not exist in that case. And so I want to focus the court's attention on the court's order at page 33. It's record 6651 is where she begins the opinion in that. And she cites specifically to the plaintiff's own allegations in the record as being the intervening factors that had to occur in order to get from point A, if you will, point A being the alleged false statements made, to point B being loss of promotion, loss of a pay raise, loss of employment benefit. And so if you look at that in the records at 6651 and 6652, she notes all of the intervening factors, including that the investigator had to decide not to interview certain people. The decision maker, the Title IX coordinator, had to make a finding that Ms. Lewis was in violation of Title IX. Also, it was decided that there had to be a finding, or there had to be an appeal, and the appeal was denied. Then you had to have an employment decision that was made by the employer of Ms. Lewis, the appellant, not Ms. Seeger or Mr. Osbury, and that was also an intervening factor, so it was too attenuated to get from point A to point B, and there was no credibility determination made. These were all allegations made by the appellant herself.
Let me ask you a question.
Sure.
How do the allegations regarding the PM 73 investigation of Lewis fail to establish causation?
They failed to establish causation because, well, you mean the entire investigation itself, Your Honor?
Yes.
Okay. It fails to establish causation, at least in part for Ms. Seeger and Mr. Osbury, because they were mere participants in this investigation. They did not direct the investigation. They did not make decisions with respect to the investigation. They merely...
She was arguably harmed as a result of the investigation's adverse determination.
Well, in fact, if you look in her complaint, she actually admits that any discipline that was imposed was removed. So there was no discipline in that case, and what the court decided was that the proximate cause factor was not met because there was not a direct injury, so that there were too many factors and too many steps that had to get from the investigation and what happened in the investigation to what she claims is her injury, which is a loss of promotion and loss of pay raise, which, as a matter of fact, are the same injuries that she alleges throughout the entirety of her RICO claim. And so what it boils down to is the directness factor, that there was not a direct correlation between the investigation and the alleged false statements and what the injuries actually, and the injuries that actually occurred.
All right, counsel, thank you.
Okay, thank you.
Mr. English, I think it is your turn again.
Thank you, Your Honor. Very quickly. The PM 73 investigation, Your Honor, was not removed from her files. USA Today did a story. They put in that story that the PM 73 investigation was in her file. Ms. Lewis is one of the preeminent executives in Power 5 athletics. The fact that they refused to pull the PM 73 investigation from her file, she has alleged that it destroyed her career. With all due respect, Your Honors, whether or not appellant has pled a viable RICO claim is not before this court. So it may not consider it. I want to go back and address, and I apologize.
One of the things that was said by a colleague on the other side is if we agree with you on the arguments that were actually the decision that Judge Morgan actually made, we can affirm on any other basis supported by the record. And it seems to me we can affirm on any other basis supported by the record. And that's where all these other arguments come up.
Your Honor, in response to that, we are confident that we have pled with specificity a RICO claim, and we invite the court to look at that in the record. I would also, Your Honor, like to address, and I apologize, maybe I wasn't clear enough in understanding your question, as to the injury and the concealment. Plaintiff alleges that in 2012, Les Miles was threatening her employment. In 2012, there was no criminal enterprise. Plaintiff alleges that the criminal enterprise was formed on May 15, 2013. We draw the court to the student complaint memo. It lays it out. So the issue becomes, Your Honor, in terms of fraudulent concealment and equitable estoppel is, when did appellant discover she was injured as a result of the violations of predicate acts of the criminal enterprise? Plaintiff has alleged that the criminal enterprise sole purpose was to corrupt and a Title IX proceeding. That was a violation of 18 U.S.C. 1512. Because of the conduct that we have talked about, of which they don't deny that they did, and because appellant was misled, because they fraudulently concealed the student complaint memo and the directive letter, plaintiff alleges that she was unable to discover her injuries that were the result of the criminal enterprise. Now, plaintiff alleges she did take reasonable steps to investigate when she asked Vicky Crochet what comes next. But this court, Your Honor, in Petrovas v. Samsung, they stated that it is not a matter of law that the appellant could have discovered her injuries, given the fact the student complaint memo and the directive letter was concealed in their offices. So the injury discovery rule of the Fifth Circuit does apply. We don't dispute that. The criminal enterprise, however, Your Honor, was formed in 2013, and that's when they undertook the steps to conceal their conspiracy, to conceal that they were violating 18 U.S.C. 1512. She simply could not have discovered that issue without seeing the student complaint memo. She had no idea. That was being hid in Taylor Porter's law offices. Judge Morgan has made a ruling, and as to the appellant's motion for judicial notice, the Fifth Circuit may take judicial notice of facts that the judge established, not her ruling, and we're not asking you to take judicial notice of her ruling. We're asking you to take judicial notice of an adjudicated fact that the Taylor Porter defendants concealed the student complaint memo, concealed the directive letter. Ginsberg concealed the directive letter in their offices. That is an adjudicated fact. That goes to as to whether or not, after the appellees formed the criminal enterprise in 2013, did appellant discover her injuries, and did she take reasonable steps in order to do so? In conclusion, that is a fact-based question. Your Honor, we ask that this court remand this matter. This is a motion on a 12B6 motion. They remand this matter back to the district court for further proceedings.
Thank you.
One question. Even were we to decide that res judicata is not properly before us, we do have a final, as I understand the facts, a final state court judgment from which the appeal is over, so it is a final judgment. Is it your position that if res judicata, if we would agree with you at all, if this were to go back to Judge Morgan, that you really do have a defense against res judicata in this case?
Yes, Your Honor.
You don't have to get into it.
Yes, Your Honor, I do. Thank you, Your Honor.
Thank you. Thank you, all of you, for your efforts to present each of your